Thank you, Ma. We really do look forward to those developments as they unfold. Now, more in business, as traders and manufacturers struggle under tax disputes, the private sector is seeking parliamentary intervention over a controversial law requiring taxpayers to first pay 30% of disputed taxes before their cases can be heard by Tax Appeals Tribunal.
The Private Sector Foundation Uganda, together with Uganda Manufacturers Association, have formally petitioned the Deputy Speaker of Parliament and the Minister of Finance to urgently amend Section 15 of the Tax Appeals Tribunal Act. The business community says the current law is locking many companies out of justice, especially small and medium enterprises that cannot afford the mandatory 30% deposit demanded before filing appeals against Uganda Revenue Authority assessments.
Over time, many taxpayers have had to challenge tax assessments. Why? Because URA has increased the capacity of number of staff who audits. The revenue targets of URA have increased, meaning that the pressure to issue assessments has increased over time. And that has meant that the only way for taxpayers to seek redress is to go to the Tax Appeals Tribunal. Now, at the Tax Appeals Tribunal, there's a rule under Section 15 of the Tax Appeals Tribunal Act, where it requires that when you make an application for independent review of URA's decision, you are supposed to pay 30%.
According to the petitioners, several businesses with genuine disputes are being forced to abandon cases because they cannot raise millions and in some cases billions of shillings required upfront.
With the increase in the number of cases, the increase in the number of amounts that are assessed, and the increase in the chances of errors being made by URA in assessments, that has meant that the amount on which such an asset is applied is quite high. Unless you don't have a cash to pay it, then you're locked out of the right to be heard by the tribunal, and URA will pay the forcing collection of the liability assessed, meaning that they can even sell your property. You can sell your part because you have to pay your tax. Yet, you have serious plans to challenge existence.
The private sector urges that the law is discouraging investment and creating fear among both local and foreign investors.
So the Constitution provides for a right to a fair hearing, but we've seen that also being contested before. Taxpayers have previously gone to the Constitutional Court to contest that, saying the right to deposit a 30% infringes on my right to a fair hearing, because if I don't have a 30%, I won't be heard. That's a summary of what they're contesting before. But sadly, the Constitutional Court disagreed with them. They escalated the matter to the Supreme Court, the highest court of the land. And still the Supreme Court maintained the same position that no, we are not necessarily infringing on your right to a fair hearing. You can still be heard. It is a requirement under the law. So if you fulfill the requirement, you will be heard. But in the event you do not, it is also an obligation you're infringing on. So conclusively, that position has been determined before. The Supreme Court has made it very clear. The fact that your matter is dismissed for failure to pay 30% is pay 30%.
Among the proposed reforms is giving the Tax Appeals Tribunal powers to waive or reduce the deposit requirement, allowing bank guarantees and security, and introducing a fairer tiered system depending on the size of the tax dispute. Ngabo Amon reporting for UBS TV.